There is a judgment which was handed down by the Constitutional Court a few weeks ago in the case of Kewanda versus the Minister of Justice, which essentially observed that the age of consent to sexual intercourse has been moved from 16 to 18. The background to this particular judgment is that in terms of our criminal law, a female at the age of 16 could engage in sexual activities, while a male could do that at the age of 18. In 2016, there was a judgment in the case of M and another versus Minister of Justice, where there were two ladies who argued that the age of marriage of 16 years for females and of 18 years for males was discriminatory in respect of females. So the court in that matter came to the conclusion that females could only marry at 18. Therefore, the provision in the Marriage Act, which stated that 16 years was the marriageable age for females, was unconstitutional. Judgment by the Constitutional Court was made on the back of that particular judgment. But before I get into the details of this judgment, I must highlight the fact that this judgment is suspended for 1 year, so it is not immediately effective. It will only be effective after the 1 year is pronounced by the court. But what is it that it is saying? Number one, the judgment is simply carrying forward what the Constitutional Court said in the case of M and another versus the Minister of Justice in 2016, where they are simply saying there is no difference between a male and a female as far as sexual activities are concerned. The 2016 judgment moved the marriageable age from 16 to 18 for females. So what this judgment essentially does is also to move the age of consent to sexual intercourse for females from 16 to 18. So there was an anomaly after the 2016 judgment to say the law allowed sexual intercourse of females between the age of 16 and 18, but it did not allow marriage. So you could still enter into some sexual activity with a person between 16 and a particular person. So that has been dealt with now in terms of this particular judgment. But obviously, Parliament is being given opportunity to align the law. It's more of alignment of the law with the dictates of the Constitution. There are obvious challenges that are associated with this judgment if someone is to read it, where the court had to explain whether the changes in the law would also affect the behavior. Some would recall that there was a government policy to say if someone or if a child, if a pupil falls pregnant in school, you just go home, you give birth, then you come back to school. There was an acknowledgement that such activities, such sexual activities do happen, and once they do happen, the society must then manage the process. That is from the time that someone is sexually active and you conceive, you are given opportunity to come back to school. I will just give an example of the law, of the amendment to the law around marriages, where Parliament had to acknowledge that in terms of law, that there are monogamous marriages. But these monogamous marriages are always associated with some polygamous elements. And as a result of that, the law now recognizes and says, no, if there is another woman who is out there, who is for all intents and purposes married to this man, that person should be acknowledged as being in existence not like before where the law would say that arrangement is completely a legal nullity. So from a human rights perspective, it is the judgment is highly commendable, but it may actually result in the violation of other rights of these minors in terms of them. Judgment does is now to interfere with the provision of sexual reproductive health services for people within this age group, because doing so would amount to a criminal offense. So there is actually need to relook at this particular judgment, especially by Parliament, as they are realigning the law. It is not a matter of choice by Parliament or by the courts to prescribe what should happen, but sometimes it is a matter of managing what may be obtaining on the ground. It should be common cause that at that age, either females or males, they may engage in sexual activities. But to completely say you are prohibited from doing that, when as a matter of fact, these activities are happening, is actually a recipe for courts on constitutional matters in the land. That judgment ought to be followed. And the only way where that judgment can be amended or toned down is when Parliament comes up with a law which speaks to that particular judgment, but it should also be in line with the Constitution. Because if Parliament is to come up with a law which appears to be against the Constitution as interpreted by the Constitutional Court in that particular judgment, that law will not survive the test if it is to be challenged in a court of law. So the remedies basically would be, especially for parents or guardians who may believe that the law is too harsh and is likely to affect the rights of these children that the law seeks to protect, is when the law, whatever this amendment to or the realignment is being made, they can have their contributions to say, yes, we are aware that there is this judgment and the law has to be adjusted or amended, but this is how we think the law should capture what we believe to be the correct thing. For instance, if or guardians or the citizens of this country, they want to maintain the issue of access to reproductive health services of children within this age group, they can try and advance that narrative as the law is being realigned. But also obviously the danger is if it is not done in a very clever way, it may still fall short of what the Constitutional Court said in the Kewata. I believe that the judgment could be held as progressive, but as a matter of fact, there are countries where the age of majority has been moved like to 21. Some they regard 16 as the proper age for indulging in sexual activities. My view is that it is not about the law, but it is about the moral behavior of children in our society. Are we able to legislate against that behavior? My view is that it is difficult. The age of 16 may be regarded as too low as far as marriage is concerned, but for the purpose of sexual activities, I believe it is the appropriate age, although people can differ from one person to the other, from place to place. Because even if we say you should not do it, but if these people continue to do it, and we then say you are denied the right to access to protective services, then we are just creating a dangerous situation for us. My assessment is that what we should prohibit rather is what should criminalize is maybe where mature people or those who have attained majority age are indulging in sexual activities with those who are below the age of 18. But as far as sexual activities between males and females who are below the age of 18, in my view, that should not be criminalized. I'm not morally, it may not be acceptable, but if once we start to criminalize that, then we are just creating so many unnecessary offenses in our legal system, because these things will always happen.